Coming up
is that you're required to name the individual record holder in trying to get access to your information. So he equated this with the equivalent of trying to get a tax assessment from the CRA, and being required to have the employee ID number of the actual employee that may have handled it.
So I guess my question is, how would you rate the job that DND or CAF are doing, based on the fact we got over 300 complaints, the number of days, et cetera, delayed? Would you describe them as being transparent and a good example of a compliance department?
So you don't have the ability to hold the department, the minister, the assistant deputy, or the deputy minister, or the chief of defense staff accountable for failure to comply with the act?
Troops returning from a deployment on commercial aircraft had to complete the ArriveCAN app. We know that the disclosure allows the app to share information to contractors working for Public Health, Service Canada, provincial, territorial, municipal, and may be used for program evaluation. Do we know whether or not any of our troops' personal information, their health information, was shared with commercial companies, state-owned enterprises, shared with anyone at all outside our government?
This guy's garage. Like and subscribe.
UPC received 10 breach reports from the organization, which are primarily related to unauthorized access, unauthorized disclosure, and the loss of personal information.
What do you consider an acceptable time frame for a privacy request related to a sexual misconduct case?
Well, it's all context-based. The legislation talks about a 30-day period for response, and then there is a possibility of extension for another 30 days. And so we would look at those cases on a case-by-case basis.
Okay, well, on April 17th, we had a witness that told this committee that complaining to the Information Commissioner and the Privacy Commissioner is not an exception to obtaining information. It's part of the process. You will not get your information unless you make a complaint. So it was put to the committee that delay is commonplace, and that the department will delay and force the applicant to complain. Any comment on that?
Well, as I've indicated, I think the bulk of our complaints that we receive deal with delays to the process in terms of access.
Okay, so is this a failure of leadership to ensure that information that openness and proper disclosure is actually done?
Well, what we see is that there are many cases where the delays are greater. We work with the departments. We deal with the complaints. We found that departments were collaborative in the complaints process as they work with us. But that is an important part of the number of complaints and volume of complaints that we receive. We try to resolve them as early as possible through resolution and expedited complaint mechanisms.
All right. Well, do you agree? The Information Commissioner in her report mentioned that senior leadership is key to influencing the corporate culture change to actual compliance and timeliness under her act. So we're now two defense ministers into later. This was a 2020 report. And we hear the same complaints of slow service, intentional avoidance, a culture of secrecy that appear to apply to requests under the Privacy Act as well as the Information Act. Do you agree that ministers must see it as their, and this is in her words, see it as their responsibility to champion a new approach and to adopt these tools and practices in order to effect the necessary changes within the department?
I agree that leadership is important, and I agree that access to information, privacy are fundamentally important legislation, and so they should be prioritized.
Okay. We also heard from the same witness, Patrick White, on April 17th, that a significant barrier and challenge is that you're required to name the individual record holder in trying to get access to your information. So he equated this with the equivalent of trying to get a tax assessment from the CRA, and being required to have the employee ID number of the actual employee that may have handled it. Do you have a concern around privacy and the level of information that the applicant for information needs to get information about themselves?
Well, I think that the department should make efforts to make the system as user-friendly as possible. And one of the themes I've been pushing in terms of privacy in all aspects is really making sure that we are not delegating to individuals and to citizens.
Is the system now user-friendly?
Well, I think we're seeing in the system lengthy periods of time, and so that's something that
periods of time for delay.
Thank you, Mr. Kelly. Mr. Collins, 4 minutes.
In a perfect world, we'd have perfect compliance with the legislation and the acts as they exist, and of course the world isn't perfect, so we have people who are not in non-compliant situation.
So I guess my question is, how would you rate the job that DND or CAF are doing, based on the fact we got over 300 complaints, the number of days, et cetera, delayed? So how would you describe DND and CAF? Would you describe them as being transparent and a good example of a compliance department?
Oh, so we have statistics in our annual report in terms of the number of complaints that we received versus departments. So there's certainly a high among the higher ones with the higher number of complaints. We have received good collaboration with them, and we're working with them to resolve these cases early. But in terms of the numbers of complaints, I think that if on the list, they would be fifth on top of the list in terms of the number of complaints that we've received.
All right, top 10. Okay, there we go. What about individuals that get a tip sent back as deemed refused? Like, what are their options? I mean, it's deemed refused, so how do they respond?
Right. Well, their option is to go to federal court. So the legislation provides that at that stage, individuals can exercise those rights. So this is the importance of that determination that we make. It opens up that recourse for federal court.
So that almost seems almost impossible for an individual to be able to go to court to do that, correct?
Well, it's something that they have to do. The onus is on them to do that.
So that's the only option. Go to court. And to incur some kind of costly legal battle to do that.
To have enforcement, again, which is where the recommendation for order-making powers to be able to have a decision that will be binding is something that we've been recommending.
Okay. I guess I got a question. Does the Privacy Commissioner have the same legal authority when it comes to taking the DND to court like it would in terms of the Information Commissioner? Is it what type of powers would you have in terms of being able to deal with that?
Well, we have important powers in terms of the ability to obtain information from the departments as part of our investigation. So we can do that. But the power that we lack is the power to issue a binding order at the end of the investigation when we make a finding. If we make a finding that the legislation was not complied with, we make a recommendation. We don't make an order. And so that's this critical difference. In the context of, there are also some who argue for there to be financial consequences, fines and so on and so forth, and that's something that's being proposed in the private sector legislation that's currently being debated in committee. But for the public sector, certainly at a minimum, having this order-making power would, in my view, make the process more expeditious, because you would have the investigation by my office, by the regulator, and then you get a decision, and then that decision is binding. And so instead of having the individual have to go to court and take those steps, that order applies, and then it would be up to the department to challenge that order in a court process.
Okay. I probably got time for one more question here. Do you think it's... What's that?
30 seconds.
Okay, perfect. Do you think it's reasonable for a requester, whether they be a junior member or a vulnerable person, to be able to actually name, specific record holders? I mean, the challenge is they go in, they need to know who's touched the file. How on earth would they ever be able to do that? Would it be an easier process for them to be able to get that information?
Well, I think that the process, I don't have a specific area on this other than to say that the process should be adapted to the circumstance, and the process should be as user-friendly as possible. If you make a process and it's very challenging, or there are disincentives for individuals to use it, that's a concern. And so the processes should be looked at. There may be specific realities in specific departments, but the idea is make this process easy to understand, easy to use, so that those rights can be exercised.
Just for clarification, Mr. Dufresne, you talk about that your office was created in 1983 under PIPEDA, and that's the same bit of legislation that was used to create the Office of the Information Commissioner as well, correct?
Not PIPEDA, the Privacy Act.
Privacy Act, okay.
Yeah.
But the Information Commissioner has the power to take the Department and the Minister of National Defense to court for failure to comply with the access to information.
That's right. So Information Commissioner created under the Access to Information Act, Privacy Commissioner under Privacy Act, and more recently, I think it was 2017, I may be wrong on the date, but C-58 amended the Information Act, the Access to Information Act, to give the Information Commissioner order-making powers. And that's something that has not been done yet.
So you don't have the ability to hold the department, the minister, the assistant deputy, or the deputy minister, or the chief of defense staff accountable for failure to comply with the act?
Not through a binding order. I can certainly, I will not minimize the impact of a public ruling, a public recommendation, and also the role of committees and so on. But I don't have the ability to issue a binding order. Okay, so that's one of the recommendations that we should be looking at. The other part of this is, do you think, and you mentioned it, that then people wanting to get access to their privacy, their own records for their own needs at Canadian Armed Forces or the Department of National Defense, they have to go to court. Do you think that's fair for one person to take on the entire Department of National Defense? Well, I think that the more efficient and accessible system is one where you can have a regulator issue an order. And so that order then is binding. And again,
happening right now.
We don't have that right now. And also, having the possibility of an order makes it more likely, in my view, that you're going to get early resolution of the matter without having to go through the whole process.
So we've heard from multiple witnesses already, including the Ombudsman, the former Ombudsman Gary Walborn, Mr. White, Mr. Drapeau. There is a culture of overclassification within the Canadian Armed Forces and Department of National Defense. Do you think that's done to intentionally hide records from their own members of the Canadian Armed Forces and veterans?
I don't. I think that the legislation provides certain exceptions for disclosure, either under my legislation, Privacy Act, or Access to Information Act. And so departments have leeway with that. There's some valid public interest reasons to prevent disclosure, or both under legislation, but the recourse exists to challenge those.
Okay, I'll give the rest of my time to Ms. Glant.
She's a little over a minute.
So how often are the military personnel system records audited for unauthorized searches?
I have statistics of the complaints we received at my office. So we would receive complaints directly from Canadians, and I've indicated that I think in the last 5 years we received 300 complaints.
All right. So what is the privacy policy with respect to military personnel health records and access to those records by VAC?
Access by VAC, there is some exchange of information between the two institutions in terms of those types of records. We have been engaged, we've been consulted on that. We understand we've received some PIA's privacy impact assessment on that.
Right, so troops returning from a deployment on commercial aircraft had to complete the ArriveCAN app. We know that the disclosure allows the app to share information to contractors working for Public Health, Service Canada, provincial, territorial, municipal, and may be used for program evaluation and other organizations. Do we know whether or not any of our troops' personal information, their health information, was shared with commercial companies, state-owned enterprises, shared with anyone at all outside our government?
Very briefly, please.
We are currently investigating the ArriveCAN app following complaints, so I won't be able to speak further on that as this is ongoing.